friends, welcome to my channel. This is a girl Mercy. I'm here again to give you those tips to help you excel in your practice. So today I'm going to talk about something I tagged before you sue. That is factors you need to consider before you institute an action. Sometimes lawyers are under pressure to go to court, and when they get to court they see that the suits they have instituted does not hold any water, and at the end of the day they are embarrassed. The client will say, I thought you're a good lawyer. Being a good lawyer first starts with understanding these basics, which is what are those things I need to consider before I institute an action. As a lawyer, you must know that you owe a duty to the state, you owe a duty to the profession which you belong to, and you also owe a duty to your client. If you're a returning subscriber to this channel, I thank you for watching always. If you're new here, please subscribe, click the like button, share this video, because I know it will help someone out there. So today, in continuation of what I was earlier saying, I tagged this topic today before you sue. What are those things you need to consider? The first thing you need to know, you have to ask the client whether this brief they are giving you has been given to a lawyer before now. If that is the situation, you need to encourage them to properly debrief the other lawyer. It won't be nice you collect a brief that has already been given to another lawyer. Ensure that other lawyer is properly debriefed and his fees paid before you start. That is part of the duty you owe to the profession. Another thing you need to understand, you need to know the full gist of the brief. You need to know what is the storyline. As a lawyer, I encourage my clients to write down their stories. When they write it down, they give it to me, I go through it with them. If they can't write, during the client interview and counseling, I write it down myself and I read it out to them to understand, is this your story? Because sometimes you've gone to court and you now see that what you even know about the issue is just 2%. And by the time the defendant counsel comes with this whole story, you are stuck, you're embarrassed, you need to start amending and a whole lot. So you need to know the whole gist of the matter. Another thing you need to consider too, when the story is being told to you, you need to look at it. Ask yourself, is this matter, is it frivolous? Is there merit in it? If I go to court, am I going to achieve anything? Lawyers are fond of rushing to court without analyzing their matters. Some matters are frivolous. When you proceed to court, you're getting nothing. So sometimes you need to, in your office, you can settle some matters as a lawyer, because you owe a duty to the profession to uphold the profession. So if the matter is frivolous, there's no need going to court, because you're getting nothing and you're going to allow your client spend a whole lot and get nothing at the end of it. Another thing you need to consider, who are the parties? Sometimes you've seen lawyers suing non-juristic person. There are juristic persons and non-juristic persons. You need to know, do I need to sue the Attorney General? Do I need to sue the Executive Governor of the state? Do I need to sue the Commissioner of Police? Do I need to sue the Ministry of this, Ministry of that? If it's a corporation, who do I sue in that corporation or organization? These are vital things you need to know. You need to know who are the proper parties. Are there statutory parties? Who are those I need to sue? Your understanding of this helps you to direct your suit to the right person. Sometimes you see in court where parties' names were struck up because they were not necessary parties. They ought not to be in that suit. So don't be caught up in that whole lot of problems. So analyze, who am I going to sue, and get them right. Another thing you need to understand too is that where a client briefs you and you don't really understand the recent position of the law on the issue, you can ask the client, let me give you a legal opinion on the issue before we proceed. That way, it gives you opportunity to go back to research. In bringing out the legal opinion, the client will be like, wow, this lawyer knows what he or she is saying. Because sometimes when you advise the client with the law which don't know that it has, there has been series of cases that have upturned the view you have, then at the end of the day, they will see you as a lawyer who does not know what you're doing. Another thing you must consider is the venue of the court. Which court do I need to sue this matter? That's the proper court. What's the court I need to go to? Do I need to go to customary court? This matter, does it befit the federal high court? Is it a state high court matter? Is it a customary court? Is it a national industrial court matter? Is it a magistrate court matter? So these are things you need to consider before you institute an action. Now, in instituting it, you need to also know the venue of the court. Now, if it's a state high court matter, do I need to institute it in Lagos? Do I need to institute it in Abuja? Do I need to institute it in Akwa Ibom? Do I need to institute it in Calabar? These are things you need to consider depending what I'm going through, evaluating the storyline. Another thing very important you need to consider is there a reasonable course of action? Sometimes you see, after evaluating the matter, you see there is no reasonable course of action, and when you get to court, just one preliminary objection, the matter is struck out. You know that course of action determines whether a matter is justiciable or non-justiciable. So these are things you must consider. You must know these things so that at the end of the day, you know when you're heading to court, you know that you're getting it right. Another thing you need to consider: does your client have the local standard? You know, people call it local standard, some people call it local standing, depending on your pronunciation. So local standing is the legal right to sue. Does your client have does it have a remedy? Has the right been breached? And that, you know, this matter, is he entitled to sue? Sometimes some matters, when you look at it, you see that this thing has to be in a representative capacity. I need to sue in a group. You know, it might not necessarily be this particular, my client might not really be the one who is directly affected or stuff like that. So you need to know whether your client has the legal standing to sue. Another important thing you need to also understand is statutes of limitation. Some matters, especially in civil matters, there is time limit tied to different categories of claims. Paraventure, like example, land matter, there's a particular time limit tied to it. So sometimes people come up with wonderful stories, but the time has passed. If you get to court, the lawyer on the other side will file a preliminary objection that the matter is statute bad. But in criminal cases, there is no time limit according to crime. You can institute a criminal action at any time. But instances like rape, you can't wake up 20 years after to say somebody raped me, because even if you can institute an action on that, but your possibility of winning that matter is slim, because issue of reporting to the police, the medical examination, time has overtaken these factors, and to be what the defendant counsel will be hammering on, and we end up losing the case. So another thing too you have to understand is the cost implication. Sometimes a client comes to you to say, counsel or lawyer, look at this person is owing me 200,000, and you check, by the time you file the suit, the lawyer fee, it doesn't make sense going to court. What you can do in that instance is to encourage your client to embrace alternative dispute resolution. That's ADR. You know, you can sit down with the client or refer the client to the multi-door courthouse where parties sit down and itemize the issue